Hi, my name is Dan Cuthbert, partner at Freeze, specialising in telecoms property litigation. And today we're going to be doing the exciting seminar on the Electronic Communications Code. And hopefully this will all work seamlessly, as I'm not used to Zoom, I'm afraid. So what are we talking about? Right, well, this is a greenfield mast, fairly classic, lattice tower, huge antennas on the top, number of dishes, probably a fiber cable running underground to the site itself. This is a rooftop telecom mast. Normally you find these around plant room or the lift shaft or around the corners of your building. Normally they want to be on the absolute highest point of the property, but because of exclusion zones, which I shall come on to a bit later, they quite often need to be as close to the edge as possible of the buildings. Here, it's probably not 5G antennas. We're probably looking at 4G or 3G. We've got some dishes, and this is a fairly usual construction. You'll see this dotted about our cities all over the place. This is a mast which you sometimes see or don't see because it's so well camouflaged, so that they can build these ones which are shrouded or which look like trees. They tend not to because they tend to be much more expensive to make. The other types of electronic communication apparatus that you will see is cabling. And this, I've depicted cabling as a fluffy white bunny rabbit because generally in the past, under the old code, we've tended to see the cables, the broadband, those types of Wayleaves as less, as sort of more innocuous. They're fragile agreements, personal licenses between the parties, which in the past we've sort of ignored to some extent. But I would say now, under the new Electronic Communications Code, they're more like the bunny rabbit from the Holy Grail. If any of you have ever watched that film, it's a vicious killer. And the fact is, the reason for this is that the Wayleave agreements that previously we were all relatively happy to enter into, to get into our offices, to get into our residential homes, civic centres, whatever it might be, they are now coming in under code agreements.
Excuse me, Dan, can I just stop you there, please? Sorry. I don't think your slides are moving on. Would you be able to click for the next slide,
right,
please?
I have been clicking for the next slide.
Have you?
That's not good. Oh dear. So you definitely can't see.
I can only see the first slide. A few people have mentioned it as well.
I'm not sure. I mean, it's up on my screen. Hold on, I'll stop share and I'll try again. Sorry. 1 second. This is not good. Share screen. Can you see the bunny rabbit?
Yeah, that's okay now. Thank you.
Can you let me see if you can you see the new slide?
Holy Grail, yes.
Okay, great.
Thanks, Dan.
Apologies. I'll flick back so you can see the other ones as well. Apologies for that. I didn't realize it wasn't showing. So as I was saying, this is the lattice mast. This is the classic sort of rooftop, probably around a plant room or a lift shaft. This is the tree, or attempt to be a tree, and this is the bunny rabbit I was referring to earlier. And as I say, look, it's these cable Wayleaves are much more problematic under the new code than they were under the old code. That, in essence, the agreement that gives the operator the right to lay his cables has all of the same elements as what you would typically see with a mast lease. So all the code protections, all the problems with being able to terminate, which I'll come on to through this talk, they all exist the same for Wayleaves. So you have to be very careful. And as I'll come on to later as well, the operators don't generally play particularly fair. So take this. This is Virgin's Wayleave, but it's very similar to BT. BT and Virgin have 3 sets of Wayleaves that they will try and get you to sign up to, and this is the first one that they try and get you to sign up to, because it's the one that is most onerous on you as the landowner. Oh, by the way, I should have said, I will, if you do wish to ask any questions throughout this webinar, please try and add those questions into the appropriate box, and if possible, I'll try and come to them at the end and answer those, as I try and make this a little bit interactive. I know it's difficult with a webinar. Okay, so this is a Virgin's classic one-page Wayleave, and it's extremely problematic. You would never want to sign up to this for anything that was at all important to you. The rights are contained at the bottom. They're very broad. They're over the entirety of the property. The Wayleave is essentially perpetual, although they allege it can be terminated by providing Virgin Media with 3 months' notice. But of course, as I'll come on to, and you'll see in a minute, it's extremely hard to terminate one of these Wayleaves, and there is a statutory process to do so, and it's an 18-month notice, and as I'll tell you, there's almost a triple lock before you can get rid of one of these. And that can be very important, as I'll also come on to. That they want access to your property at all times. That's another biggie. They appear to be offering some kind of indemnity, but in fact, there's no indemnity in this agreement. They talk about a liability cap at 10 million, and yet nothing in here gives them any liability. There's no indemnity that you would normally see linked to that 10 million or insurance or whatever it may be. So this is a very difficult Wayleave to deal with if you are the council. What you want to be saying is, please can I have the A1000 or the A5000 in the case of BT, which is much more detailed, which contains lift and shifts, which contains indemnities, which contains a lot of the obligations that you might hope to see. Now, those agreements still aren't perfect, but they are taking you some way forward to what you would want, and really it's only because these guys have sort of slipped under the radar for so long that we're seeing these come through. So stepping back a little bit, well, why are we where we are at the moment with the electronic communications code? Well, the government was sold a wonderful dream, and that wonderful dream is one that I also believe in. Broadband, great 5G, all these things are going to make our lives potentially hugely better, and going to make business life hugely better. Who doesn't want, and particularly as we're finding out in this pandemic, who doesn't want great video call meetings? Who doesn't want to have great systems that they can operate anywhere? 5G and good fiber is meant to open up huge amounts of things like driverless cars, remote surgery, systems talking to each other. So you got your fire authorities talking to your police, talking to your local authorities, talking to the hospital, and a huge amount of data is passing backwards and forwards. And in order to facilitate that, the government was told, well, look, we are going to need to roll out a major program of investment in this country. And this is the kind of thing that they were saying pre the introduction of the new code. we are going to need lots and lots and lots and lots more towers dotted all over the place, because although 5G is wonderful, it has a smaller range than 4G and an even smaller range than 3G. So as you go up these frequencies, the range decreases, and therefore you potentially need more and more sites. And here you see them saying that they would need 400,000 towers, and that they would need to spend a huge amount of money, and they wouldn't be able to afford the rents if they had so many towers, and therefore they were pushing for a new code that would give them additional powers and reduce those rents, most importantly. But prior to the new code, which came in on the back of the Digital Economy Act in 2017, we'd had a fairly long and stable period of sitting under the old code, which came into being in 1984 and was barely amended by the Communications Act 2003, where it currently sits, and until it was completely removed by the Digital Economy Act 2017, which brought in the new code, but which also brought in some transitional provisions, as I'll come on to. So we'd sat under this old code for a considerable period of time, and it kind of worked. When it did make it to court, which, by the way, was very rare, the judges were less than impressed with how the code was drafted. It seemed to be full of holes. It was complicated. Nobody was quite sure how it worked. As a consequence, the operators were not too keen on testing it out. But in addition to that, they already had the protection of Landlord and Tenant Act 1954 in most cases, unless it had been contracted out. And actually, this was one of the big problems that developed between the code and this new code, which, to be fair, the new code has sought to address, which is prior to the introduction of the new code, we had two statutory regimes that impacted on landowners. Going forward from the new code, we will only have the code. We won't be worrying about the Landlord and Tenant Act 1954, but as I'll come on to in a short while, it does still play a part under the transitional provision. So there's going to be a period of time, unless the code gets amended again, where we're going to see Landlord and Tenant Act 1954 cases still coming. So the old code, what did it do? Well, it did a lot of what the new code did. So operators were entitled to rely on it. It covered a wide area. So it did cover landlines and phone masts and fibre optic cables and all the rest. There was a process which the operator could follow in order to compulsorily acquire rights over your land. He did have to pay a market value, but it didn't tend to extend to the payment of a ransom, and there were opportunities for landowners to obtain compensation. So, you know, on the face of it, it gave the operators quite a lot of what they needed, but actually they turned to it only in relatively rare circumstances, at least in terms of taking these things to court. Although I think it did come as a shock for quite a while for site providers, landowners, to find out about the code, because actually in the early days and for quite a while afterwards, it slipped under the radar. And I used to, for my sins, when this was some years ago, I used to be at Osborne Clark, and I managed the team that dealt with the Vodafone work, and we did everything under the old code, and we dealt with the Land and Tenant Act 1954, and but generally we got consensual deals done with landowners, mainly because it was relatively fair. So why did the operators want to change things? Well, as I said, they were anticipating a huge rollout of additional investment. So what they wanted was even greater security of tenure. They already had pretty powerful rights to remain in a property, but they were limited. They wanted to ensure that operators couldn't assert rights as between themselves. And this was particularly the case for Arqiva and the tower companies, who were coming along and basically saying, well, this new code looks like a nightmare, actually. We can't have operators just coming willy-nilly onto our masts and infrastructure that we've built at tremendous cost, and them coming onto it essentially for free. So those Arqiva and the like fought hard and got a provision into the code whereby you wouldn't have what's called blue on blue. And the way that the new code achieves that is to exclude the definition of electronic communications apparatus from the definition of land. And you can only acquire code rights over land, but it excludes electronic communications apparatus, or ECA as we would call it, and accordingly you can't then force your way onto someone's ECA like Arqiva, and that would include their mast and other infrastructure. So you would struggle to say to Arqiva, well, I'm going to apply my code powers and you're going to have me on your mast for free. It also, they wanted to improve their rights with regards to being able to upgrade and alter and share sites. So one of the things that they were saying to the government was, obviously, we need greater flexibility to change our existing infrastructure, because we want to add a lot of 5G, and that's actually when you come and look at it, quite intrusive. These are much bigger antennas. We want to be able to share with other operators. It will cut costs and all the rest of it. We don't want to be impacted. And a strange thing had started to come about under the code, under the old code, which was called pay away. And in essence, what that meant was that operators tended to pay additional amounts of money for a site that they'd rented when they shared it with another operator, and that pay away could be anything from 20 to 50% of the income that the operator received, and they didn't like that. Obviously, they wanted to keep that money for themselves, or share amongst themselves at nil value. Although, and they set up different groups. So you've got Cornerstone, which is Vodafone and Telefonica, and then on the other side you've got MBNL, which is EE and H3G. And they'd been starting to group together, although funnily enough, the advent of the new code is starting to split them apart, because they've got so many great rights that actually they're seeing less incentive to share with each other or help each other out. And the key thing, obviously, that they wanted to achieve by a new code was to reduce the cost of the network to the operators by pushing down on the rents that they had to pay. And there was certainly a big push, and I remember this from early days prior to the introduction of the new code, to try and get a rate card to get small sums that were set in stone that would have to be paid. Whereas the Law Society, who were inputting into what the code should be, were saying, actually, no, it should be market rent as it was under the old code. And what we found was a fudge that I'll come on to in a second. So what's in it for you, the local authority, the landowner? Well, not a huge amount in terms of your property portfolios. Obviously, you will have people within your local authorities that will be looking to roll out digital infrastructure, that will want the boroughs that you're working in, and the council will be saying, come on, let's get this digital economy going. And there's pressure from government, and I'm sure some of you will probably have received letters to say, come on, make the operators' lives much easier. And that's all fair, except that as I'll come on to as I describe the new code, it's extremely onerous on your property portfolio, and it has quite a major impact on what you can do with your properties going into the future. But looking at this slide, so what we probably have as the key advantage of the new code is that going forward, we won't have to worry about those two statutory regimes. There won't be double protection, in essence, for those who'd forgotten to contract out their leases of 54 Act and code. Instead, we will just have code. Now, as I come on to, the code isn't hugely helpful, but one thing that had arisen prior to the introduction of the new code was almost this circle of death, whereby the operators who were being asked to move off were using this sort of conflict between these two statutory regimes to, in essence, say you can never remove us because you can't meet your grounds under the 54 Act because, for instance, to redevelop, because you then have to go through the old code and you won't be able to do your things, your development within a reasonable period of time. So there started to be this conflict between these two statutory regimes that the operators were using to their advantage, and that is a good thing that is going to drop away, and that you only have to deal with one regime, even if that regime is particularly onerous. The disadvantages, though, and I'll come on to the processes, is much harder to get rid of a telecoms mast. It's much harder to prevent a telecoms mast coming onto your property or cabling or whatever it might be, and ostensibly we're looking at much less income for local authorities, large landowners that have many of these. And one of the things I used to do was act for NFU members, and this was a big thing. The farming economy, for instance, was anticipating a major reduction in income of millions of pounds, and I suspect the same applies to local authorities. I do act for a lot of local authorities who are seeing this as very, very unwelcome in regards to the reduction in the money and the increase in the burden and costs that's going to arrive at the council. So, as I say, it's much harder to prevent a telecoms mast from coming onto your land. It's a relatively simple process for the operator and relatively quick. Only quick in the terms of how us lawyers understand quick, but nonetheless quick. The notice that they need to serve gives you 28 days. They generally append an outrageously bad agreement to their notice. They say sign it, or if you don't respond, or if you say you don't want it, then we're going to go off to the tribunal after that 28 days expires to ask for the tribunal to impose this onerous agreement upon you. They can make their application to the tribunal at any time thereafter. So from once the notice has expired, off they go to the tribunal. In circumstances, and really this should be the only occasion where they use it, i.e. that they're trying to get a new mast onto new property that they haven't been on before, then the tribunal is tasked to deal with that application within a 6-month period. And under the interim provisions, that can be even quicker still. So it can be a very quick process before you suddenly find yourself as a site provider before the tribunal trying to argue either why they shouldn't be there or that they should be there on a different type of agreement. And the tests that the operators need to succeed with are fairly simple as well. The first part of the test is that the prejudice to you, the site provider, cannot be compensated in money, and most things can be compensated in money, unless you're building a mast on the Mona Lisa or something. There may be certain circumstances, and there was in fact a recent case, University of Arts of London, where the prejudice, where the tribunal did in fact find that the prejudice to having this mast on the property was incapable of being compensated because it was catastrophically bad for University of Arts of London to have that mast there in a number of different ways, because they were attempting to leave the building, they wanted to go to a new property that being developed for them, they were going to get penalized in cash, but so far you could assess that amount of money. But also they were going to have huge problems, not with their students, not knowing when those students would be able to come in, where they would be going to. It was going to be a nightmare. And the court on this occasion said, actually, we don't think we can compensate the site provider in money, and it fails on that ground. But they did say it's an extremely high bar, and it's the same with public benefit. So locked into the code is the concept that there is a public benefit to the electronic communication apparatus, these networks being created. And it asked the question, on the basis that there is this tremendous benefit, is on this occasion the private prejudice to the site provider, the landowner, does it outweigh that tremendous public benefit? And as you can imagine, again, very high bar, rare that will be the case. One final thing is, if though you are proposing to develop the property and have an intention to do so within a relatively short time, then the tribunal won't be able to impose its agreement if it believes that to be the case. So how have the operators responded to the electronic communications code? Well, they've responded by going, well, in which case, this is fabulous. This works really terribly well for us. We're going to seek the maximum rights for the minimum payment. So, and they're maybe slightly starting to change their position, but certainly over the last 3 years, generally what you found was that the operators would land on your desk an agreement which gave them, if it was a renewal, much more than they had before. If it was a new site, a lot more rights than you might have seen under the old code, because now they thought to themselves, well, we can have all of these things and it's not going to cost us very much money. So let's have a set down area. Let's have an ability to put a generator where we like. Let's have wide rights of access. Let's have a bigger site. Let's have wide equipment rights. So all of these things, the operators came along and said, look, we want them, and we want them for a very small sum of money, and it wasn't unusual. I dealt with one of the first key cases in the tribunal, which was Keast, and my client in that scenario had been offered £36 for a mast, which unfortunately for us, we wanted in an area that we wanted to develop, wanted to put their mast there for £36 for a 10-year term, not £36 per annum, but £36 as the total payment that they would ever have to make. Unsurprisingly, my client was not happy and took that to court, and has so far been successful. So the other, and for me, and probably for a lot of my clients, and I act for local authorities, funds, fire authorities, developers, this is probably one of the key areas that is of concern to site providers, landowners, and that key concern relates to the huge difficulty that you will find in removing an operator from your property, either on expiry of the term or when you try and exercise a break clause. The old code had two types of notices. They were short 28-day notices. There was a process, again, that was relatively favourable, more favourable, not hugely favourable, but more favourable to the site provider. And one of those processes was a lift and shift. And in fact, it was considered that the lift and shift could take them right off your property altogether. So it acted as a kind of termination provision. And it could apply even in circumstances where there was no such right in the agreement and at any point in time during the agreement. So the old code had quite useful provisions there for landowners who suddenly found that they needed to do something major with their property, huge refurbishment or redevelopment or whatever it might be. Instead, that's gone. So those short processes are gone. Under the new code, you have to serve an 18-month statutory notice. That may be in addition to a contractual break notice. It cannot expire before the end of the term, so unless it's a break notice. So if you can bring your agreement to an end early, then you can also serve the statutory notice. You then can only seek termination in very specific grounds, and they're worse than what you might expect under the 54 Act. For instance, there isn't an express right to take back the property for your own purposes. Let's say you wanted the roof for or your field or whatever it might be for your own purposes. That's not an express reason in the new code. So the grounds that you can seek possession termination are there's perpetual breaches of the agreement, that they perpetually delaying to pay, you intend to redevelop, or that the test that we talked about earlier about the mast coming onto your land, that test isn't met. So you can't be compensated in money, the private prejudice outweighs the public benefit, and again, redevelopment. So and probably us lawyers see redevelopment as this a key area where you've got the best chance of successfully being able to bring one of these agreements to a close. Once you've served your 18-month statutory notice, the operator has 3 months to serve its counter notice. If it doesn't, that's a strict requirement, and you will be able to seek termination. And then the operator then has a further 3-month period within which to issue its proceedings. So off to court, off to tribunal you go. If you can manage to substantiate any of those grounds I referred to earlier, then fantastic, you get your order for termination. If not, the operator obviously retains its rights, and it depends then, there's a menu of options as to potentially what might happen going forward from that point. Maybe a new agreement, maybe the old agreement continues, maybe the old agreement continues with some amendments. So there's a menu that we can look at there. However, and this comes as something of a shock to many clients, particularly developers who are hoping to get on site and are already upset about the tremendously long and difficult process that they've just followed. They've got their order, and obviously they then get the uncomfortable news that that's not the end of the process, because there's a further notice that needs to be served, giving the operator a reasonable period of time within which to remove its apparatus. There isn't any guidance on what a reasonable period of time is, and I think there is a real risk that the operator is going to turn around and say, I need 18 months, because that's the amount of time they say it takes for them to find an alternative site, make arrangements to move to that site, and so on. Now, you may say in reply, hang on a minute, you've just had 18 months. We've served an 18-month notice, and I suspect you might find that their response to that is to say, well, we didn't think you were going to succeed, so we haven't taken any steps to move. We need to stay. And you know, they're going to go to tribunal and say, well, look, you know, we can't go in this short time scale. It'll do terrible damage to the network. You need to allow us to stay. Whereas the developer is going to be absolutely flabbergasted and jumping up and down and going, come on, you've known for a long time that we need this property back. The good news is that after 28 days from service of the notice, the site provider can go off to the tribunal for a second time to seek an order. If it hasn't managed to agree a date for removal with the operator, then it can go off to the tribunal and say, I would like you, the tribunal, to order the operator to remove the equipment within a particular period of time. Fantastic. Finally, we've got our order seeking the operator to remove, and he doesn't remove. You can then go back to the tribunal for a third time and seek an order in that scenario, allowing you to remove the apparatus yourself, recover the cost of doing so from the operator. So that is a very long-winded, time-consuming, and expensive process to follow. And it will mean that developers are going to be less interested in sites where there is telecommunication apparatus in situ, and it's not unusual to see a chip on the price. I acted for one of the top 4 house builders. We bought some land from the government for about £50 million, and there were a lot of apparatus on there. And we told the government that unless you were able to remove that apparatus, we were going to reduce the price by £6 million. So you can get quite substantial chips, and I would say in most cases a valuer is going to say, well, actually, I think there might well be some diminution in value to this property, but we don't really have the case all yet to back this up. So key points. So under the new code, I think key is you are able to resist the application of a telecoms operator coming on site if it intends to redevelop. Redevelopment can be all or part of the land in issue or neighbouring land, which is important. As I say, it's a bit unclear about the tests and the timing in terms of when you might need to be able to exercise your redevelopment. So far, we've got one case, University of Arts, where there's been a successful application. But what the University of Arts, in my view, shows me is that the operators are, even in circumstances where it looks very clear that there is going to be a redevelopment, that they are still going to make life quite difficult for the site provider and make you jump through the hoops and hurdles in order to remain on site. As I say, the old code had a statutory right to lift and shift, and potentially that lift and shift took it off the property altogether. That is gone, and is a key thing that you need to ensure, both in those Wayleaves we were talking about earlier and in your code agreements, that you have the ability to lift and shift contained in that agreement, because if you haven't, it won't be implied by statute. So consideration and compensation. To be honest, this was initially probably the biggest area, the biggest bugbear, the area that got the most focus, and I think probably the tribunal still sees the consideration compensation point as the reason why there are so many cases in the tribunal. And I can tell you that there are more. There've been much more cases in the last 3 years in the tribunal under this new electronic communications code than there were ever under the old code, so considerably more, and the old code was over 30 years long. So you can see that it's been very litigious, and one of the beliefs of the tribunal is that it's all down to consideration, and there's probably some merit in that, because as I say, the operators took quite a hard line and started offering extremely low sums of money to site providers, landowners, to be able to use their properties on very onerous terms, and that didn't go down particularly well. What had been thought would be the case prior to the introduction of the new code was that you would see drops in rents by about 40%. Instead, the operators went for drops in rents of about 99.9%. And the reason for this, and the key point on valuation when it comes to consideration, is that it's done on a no scheme basis. So it is a market rent, but you're seeking to value that market rent on the basis that you're not using this for telecommunications, and that is potentially catastrophic for value, because a lot of these sites only have value to the telecom operators that were using them. So that bit of roof, that corner of a field, the operator said, well, actually, apart from us, no one else wants to use it. It's got a nominal, if not a nil value. So why shouldn't we only pay 40 quid to go on there? You are also entitled to compensation. If the tribunal orders an agreement, then it may order that the operator pay compensation for any loss or damage sustained, or that will be sustained by the person due to the exercise of the code right. The person tends to be also entitled to seek compensation for his costs, diminution in value to the land. Those are sort of key areas, and this is why the operators are obliged to pay the costs of putting in place these new agreements. So when you're negotiating with the operator, trying to put one of these complicated and horrible agreements in place, they should be paying for that privilege, and they will try and limit costs as much as possible. So far, the court has awarded about £3,000 in one case. In the Scottish case of Fotheringham, the court refused to put an arbitrary cap on the solicitor's fees, of which the operator was seeking 1,600. The site provider was saying it was much more than that. But these costs come into the compensation provision. Now, very, very importantly, and this is probably one of the, there's multiple bear traps, by the way, in these agreements, but one of the, probably the biggest bear trap that everyone, a lot of people are falling into, is that compensation isn't something that you'll necessarily obtain if you voluntarily agree your agreement, because the compensation provisions of the code talk about it being provided in circumstances where the tribunal awards the agreement. It's so if the tribunal isn't being asked to award the agreement, it is vital that you have compensation provisions contained in your agreement. And those compensation provisions are extremely useful because they will take you into the ability to get money in circumstances where you suddenly find that the existence of the operator is having a very negative effect on your property, normally in relation to your ability to develop. So absolutely crucial that you have a compensation provision in the agreement. The operators, funnily enough, are resisting this. They try and get away with not telling you about the compensation right, or they try and put a compensation provision in which they've already paid normally your solicitor's costs or whatever it might be as a one-off payment to cover all compensation going forward, and thereby denying you the sort of code rights to future compensation payments. So you have to be extremely careful. The operators aren't playing particularly fair and are taking advantage of lots and lots of lawyers and people that don't know their electronic communications code particularly well. And we've had a number of cases, and actually the cases have been slowly going the way of the site providers. Initially, it was tough in the tribunal, being a landowner site provider. The tribunal was very much tasked with making this code work for the benefit of the operators, but I think even the tribunal started to be a little bit concerned with the way in which the landowners, site providers were being treated by the operators. And you got a few comments from Martin Rogers, who's the deputy president of the tribunal, to the extent that maybe they could improve their wooing of the site providers, that they were being a bit rough, and actually that criticism has increased over time. To be fair, it's been ladled on both parties, because site providers, who often have their backs up, have also started to behave pretty badly towards the operators. And what we've seen is that those 50 quid, 36 quid rents that the operators were seeking to achieve, and which actually they got an initial great deal of comfort from a case which was unfortunately run by the London Borough of Islington, which gave a nominal rent of 50 quid. It ended up as £1,000 with some other add-ons. But it suddenly looked, the operators were like, yes, we were right to take this very aggressive approach with rentals. We should be getting, we should be paying very little. And it just encouraged them to do more. Now that tide has been turning, and we have now got some decisions. And this one, which is Cornerstone Telecommunications Infrastructure Limited in London and Quadrant Housing Trust, very recent case, we're starting to see the move back to more reasonable rents. This was a rooftop site. You've still got your nominal site value for 50 quid, but the tribunal's starting to go, well, actually, is starting to be convinced that there are burdens to having these operators on the property, and that the operators should pay for that. And it's a bit odd because it feels like compensation, but they're applying it into consideration. And actually, what we've learnt is those people that held out as long as possible has been a good thing, because there's lots and lots of people who've signed up to very prejudicial leases at very low rents because they just didn't want the hassle. Whereas in fact, we're now starting to see rents of about 5,000 for a rooftop, about 2,000 plus for a greenfield, and Martin Rogers, I think, is trying to create a rate card, which was what the operators wanted in the first place, but at a higher level, because he thinks if it's more market value, the site providers are probably going to be a little less annoyed by having the operator in their property. And what Martin Rogers said at paragraph 154 of the case is, for the assistance of parties in other cases, so this is a warning to everyone, that while each reference must be determined on the basis of the evidence presented to the tribunal, the evidence we have considered in this case gives us no reason to expect that the market value of a site provider's agreement to confer code rights over a rooftop site on any different residential building will be much more or less than the sum of £5,000 we have determined. There may be features of a particular building which justify a modest range, but we would not expect variations to be significant one way or the other. The evidence does not suggest there is much difference between the value of a site on a residential building in inner London or in Sheffield, and we would be surprised if values in other parts of the country were not in the same narrow bracket. Now, this is a clear instruction to the operators, to the site providers: stop coming to me with arguments over rent. It's going to be £5,000 if you're slapping your equipment onto a roof on a resi building. As I was saying earlier, there are certain situations where the 54 Act will still apply. There are transition provisions contained in the Digital Economy Act 2017, and you're probably going to get one more bite of the cherry for all of those leases which are 54 Act protected. And that is likely to mean that you will retain an increased rent, get similar terms to what you had before, but you will have a code lease at the end of that process. And ostensibly, there's no requirement to pay costs, because the cost, although cost was generally paid under the old code for the site providers, legal fees and agent fees, it's actually that the requirement to pay costs falls within compensation. I probably need to rattle through this a bit quicker because I don't know how much time we've got left. Julie, do you know how much time we've got?
Yes, till 11 o'clock. We've got a few Q&As as well, Dan, if you wouldn't mind.
So they're building up. I'll try and rattle through a bit quicker. I don't mind staying on a bit longer if people want me to. I don't know if that's possible. Julie's in charge.
That's fine. Thank you.
So there was a case, it was a 54 Act case, Vodafone, which was misspelled by the court, so it's with an F, and Hanover Capital. It was a lease renewal. Martin Rogers agreed it was a 54 Act lease. In this case, they said if it had been a code rent, it would have been 2,000 or 2,500. However, because it was under the Landlord and Tenant Act, a rent of 5,750 was obtained on a 10-year term, with a break at the 5th year. This was over a car park area. One of the key arguments that Martin Rogers appeared to suggest was a key reason for the additional rent was that there was more than one operator interested in the site, actually, which you'll often find is the case for most sites. There is a process for renewal under the code contained at paragraph 34. An odd set of provisions that the tribunal needs to take into account: the operator's business and technical needs, the use of the site provider is making of the land to which the existing code agreement relates, any duties imposed on a site provider by an enactment, and the amount of consideration payable by the operator to the site provider under the existing code agreement. And this 3413D is the kicker for the operators. The reason they've been fighting so hard not to have 54-hour renewals, and they're doing this by hook or by crook, by either not telling, saying, oh, this is just a code renewal, I'm not telling you that actually the 54 Act applies, or in the past, but they were wiped out by a couple of cases, Compton, Ashlock, and AP Wireless. They were trying to argue that they could use their paragraph 20 new site compulsory powers in all cases, and therefore they didn't have to worry about renewal. The reason they're worried about renewal in particular is D, because if you get your first renewal under the 54 Act and you lock in a high rent, the tribunal will have to take account of it under 34.13D. And that's quite important because there is a provision, the transitional provisions of the code, that prevent the 34.13D from being applied to the first iteration. So the first lease that's granted after the introduction of the new code, that doesn't need to look at the old code rent. But once you've got a rent that's been put in place after the introduction of the new code, that will need to be looked at. And that's why they don't want to do 54-hour renewals particularly, because they think that they will lock in a higher amount of money. There's also a black hole, and this came about by those arguments that we talked about earlier. They were saying, well, we can always use paragraph 20, which is our compulsory purchase powers. We can come onto the land. It doesn't matter about renewal. If we're already there, it doesn't matter. Court has said, no. Paragraph 20 is for situations where you are trying to come onto a fresh site. The outcome, though, has been quite bad for the operators in seeking to use this process. What's become apparent is that there is this black hole. There's some leases where ostensibly they're stuck, and those leases are either where they're sat under periodic tenancy, protected by the 54 Act. They're stuck because of a quirk of the 54 Act, which requires, which says that Section 26 notices cannot be served by the tenant. Where they sat on a periodic 54 Act tenancy, they have to wait for the landlord to serve a Section 25. So that's a big problem for the operators, because they can't actually trigger the renewal process to get themselves into the new code. The second black hole is where a tenancy at will has arisen. So what's happened is the contracted out tenancy has expired. The parties have continued to negotiate, and that tends to mean a tenancy at will is created. That doesn't meet the conditions of the code of requiring a subsisting agreement. And again, the operator can't find a way into the new code and can't exercise any of his rights under the new code. So they've got this swathe of properties where they're stuck, and they don't like this. And so what things I've been doing for likes of Hackney, Enfield, and other councils is we review the portfolio that they have, and we pick out our properties where we've got actually a much better chance of having a successful rent renewal. And we probably want to do that now, because I can tell you the operators are lobbying and spending tons of money to get the code changed again, and it's only going to get worse for landowners and the site providers, unfortunately. As I say, operators generally won't play fair, so they're not going to tell you about the black hole. They're not going to try it. They're not going to tell you to do the renewal under the 54 Act. It's very common to see letters saying, a generic letter which says, we've got these code powers, we need to renew, you should know that the Electronic Communications Code is now in force, and we are therefore entitled to no rent and these onerous terms, and suck it up. They then, on the ones where they're in a black hole or 54 Act, they don't always then push forward with their case. But we are starting to see more and more Section 26 notices as they finally, I think, started to accept that they won't be able to get around that process, and they're getting that, kick-starting it off. As I said earlier, compensation, again, they're generally not going to tell you that you should make sure you have compensation provisions in the new agreement. That's very important. They'll often try and seek unlimited rights to upgrade and share. There are provisions in the code that potentially restrict sharing and upgrading, although the tribunal feels that it might be able to subvert those if it wants to. For my sins, again, I was part of the GLA process creating those GLA templates, which, by the way, are very onerous. The operators got a lot of what they wanted. It was very hard work. It was mainly operator-led. There were a few of us who were site providers who were fighting for things, but one of the things they wanted as a starter was unlimited rights in the agreements, but they don't want to pay for that. There's lots and lots of traps for the unwary. Unfortunately, the agreements have multiple issues that you do need to cater for, things like exclusion zones, ICNIRP responsibilities, your own responsibilities under the control of electromagnetic fields at work regulations 2016, which I'll come on to in just a second. Probably need to speed up even more. So health and safety, I mean, this is a big one. This is a really big one, actually, for councils. I've got 6 now cases acting for local authorities where we are pushing back against the upgrades that are being proposed by the operator. And the key reason we're pushing back is we're concerned about the exclusion zones that are being put across our clients' property or into our clients' properties in some cases. And this is particularly apparent with 5G. And unfortunately, it's you, the site providers, you, the landowners, that have responsibilities under these health and safety legislation, under the Health and Safety Work Act 1974, Management of Health and Safety Work Regulations 1999, Control of Electromagnetic Fields at Work Regulations 2016. These regulations hit you, and you have responsibility. So under SEM4, you're looking at it's your responsibility is to assess the levels of EMFs to which your employees may be exposed. You've got to ensure that their exposure is below exposure limit values. You've got to take action if employees are exposed to EMFs in excess of those limit values. You've got to devise and implement an action plan to ensure compliance with the exposure limits. You need to assess the risk of employees' exposure and limit or minimize those risks. You've got to ensure that employees at particular risk, such as expectant mothers and employees, and you won't always know whether someone is pregnant or not, are particularly cared for. You've got to provide training, you've got to provide information, and the big source of EMF, electromagnetic fields, is, guess what? The massive antenna that you've got sitting on top of your roof. And unfortunately for you, Cornerstone in particular, CTIL, who do Vodafone and Telefonica, have now started to refuse to provide you with details of the exclusion zones, so the impacts on your property, so the areas where you shouldn't be entering. And this is really quite important. And these are example exclusion zones. They're very big. They're split in two. You have what's called an occupational zone. No one should go in that. And then you have a public zone where members of the public should not go into that area. What operators are trying to argue is that the green area, the public, well, if it's on a rooftop, the public should never be going onto that rooftop. Everyone else are your employees and should be trained in electromagnetic frequency awareness, and therefore they can happily move around in this green area. To me, that's nonsense. The green area isn't a risk-free area just because you've had training. It's still a problematic. And even if the operators are right that all your employees are never going to be members of the public, an expectant mother, someone who is pregnant, is always a member of the public. As I say, you won't know if one of your employees who's going up on the roof, or contractor, or whoever it might be, isn't pregnant and isn't going into a public exclusion zone. So you therefore need to know where these are, and they need to be locked off. And actually, the impact of the exclusion zones, the fact that you can't go use large areas of your property, should be catered for by switch off in the agreement. And actually, you may even think there's a value to this, because you're not just talking about a small area, a site area. You're talking about a much wider impact, because you've got an area of your property, particularly that picture I showed earlier, where you've got the masts around a lift shaft. That's going to be pumping out exclusion zones across the entirety of your roof, making life much more difficult. This is it on a side view. 5G again is problematic. It looks more like a sort of submarine with a fin. It penetrates down directly below the antenna, and it penetrates behind the antenna as well. So there is an area behind the antenna which will be impacted. So even though the antenna may be at the edge of the building, there may be areas at the back of the antenna and just below the antenna where there might be problems. So it's really important to know, have the information, just understand whether this is causing any problems. And I have seen exclusion zones that are taking out your plant room because they stretch over the plant room, taking out the roof, penetrating into the opposite building, penetrating down into the building that they're sitting on. So this is an area of concern. This is another example. Here you've got your antenna. The blue zone is your occupational zone. The red is the public zone. And as you can see, it is penetrating down into some of the units below. And I don't think they would be able to get away with an argument that this is going to only be entered into by employees. A similar example here. And then there's other issues with the antennas. So when they are pressed right to the edge, sometimes they overhang. You've got to be very careful when they're undertaking their works. So you do need to insist, just because they have rights to upgrade or alter, and often they're very uncapped, contained within the leases that they have already with you. You do need to make sure that they do things safely. There are lots of horror stories. You do have situations with them doing work, not putting in proper drop zones. That does need to be looked at. It's worth having an agent make sure, check over everything that they're doing is being done properly. There's a cost to that, but you should look to recover that cost from the operator. Here's another example. You can see that this is actually hanging. That apparatus is hanging over the entrance. So when they're going to do work to that, create a drop zone, they're going to have to close off that entrance if they're going to do things safely. You often find that the weight of the antennas starts to cause structural problems to the roof. Again, you probably need, in certain circumstances, the operator to engage a structural surveyor. You may want to engage your own surveyor. The problem with 5G is that it's getting heavier, or massive MIMO. So these antennas are getting bigger, heavier. They're not always checking things properly. I have heard stories, one situation where they thought that there was more foundations than they'd anticipated, another where they thought it was a concrete roof. It turned out to be timber, couldn't sustain the 15-ton weight that was being put on top. So there are legitimate concerns that you might have with health and safety issues in the nature of the install itself. And this is an example. You can see the antennas becoming bigger and bigger as they move up the generations and deliver 5G signals. So for me, the key problem with the code, look, I'm not a Luddite. I do think there's tremendous good created by having fabulous digital infrastructure, by having great fiber connections. All our tenants want these things, but you do need to be aware that you are going to lose some control over your property. They're very difficult to move. They tend to seek wide rights. It becomes harder to develop, refurbish, repair your properties. You might find that you're starting to get a diminution in value to some of your properties where you had some development value. You need to think about things like being able to switch off this equipment. You need to minimize the risk of these exclusion zones. That probably needs to be on your radar, because the exclusion zones are so problematic. You don't want your staff being impacted, or contractors or guests or whoever, or residents being impacted by EMF. This could be another scandal in the making, so it does need to be dealt with. This information should be requested. MBNL do provide their exclusion zone information. I don't know why CTIL don't, or why Cornerstone don't. Make sure there's lift and shift. There's so much to, the problem I often see is that a lot of people see the agreement because it's low value as being low importance, but it might be low value, but the impact it has on your property is very, very high, and therefore needs to be taken very seriously. You do need to make sure this is being dealt with properly. Otherwise, you're just building yourself up problems into the future. You can do that. They will engage in negotiation. you can make amendments to these agreements. You can try and soften the blow. So, and that's probably where I'll end the talk. So I'll just see if I can look at your questions and see if I can answer any of them. Let's have a look. Julie, I'm struggling.
Right, okay, then I'll start to read them out. We probably won't be able to get through all of them.
Yep. So actually, I can now do it. It's fine.
Oh, okay.
I've got them. That's good. Okay, so John Wass, where pre-2017 lease includes rent review provisions, are reviews post-2017 to be determined under the old legislation, i.e. market rent, or new legislation, i.e. disregard the existence of the network? I think the old style, it depends on the terms of the lease itself, but I think you've got a reasonable argument to say that the review should be on the old basis, not the new basis, not the no scheme basis. What they'll argue in reply is that the hypothetical scenario is that it is in knowledge of the new code, and therefore that should apply. And that's what they've been running in the 54 Act cases. So there may it's a bit grey, that one, and it could go either way. But I would certainly push back in the first instance. So what John, again, can Dan elaborate on what the maximum timescales would be for a potential redevelopment that would frustrate an operator's request for a new code lease? Well, I think, unfortunately, there isn't much guidance as to when your development should be taking place. It's likely to be very similar to what you have under the 54 Act. So I think a reasonable time after expiry, you should be, moving towards development. And I think probably much of the same proof and evidence that you would need in a 54 Act redevelopment case, you'll need in a code case. So you get all your ducks in a row, get your planning, get your finances in place, get your board minutes, get your council minutes, whatever it might be. Get everything aligned for the best possible situation. As I say, it's extremely difficult managing development in a situation where you've got a code operator in situ because of the uncertainty of the timescales and development. You need to know when things are going to be happening. Small cell deployment, well, those will be under code agreements as well. They're exactly the same, so all the issues that apply there apply with small cell deployment. Okay, David Boyne has picked up that diminution was 6 million off 60 million. Maybe I was getting my figures wrong. Okay, thank you, David. David, is there any reason other than the operator's refusal we can't ask for an indemnity clause in a new code agreement covering the SP's costs incurred in removal of the installation when the lease is terminated or redevelopment? No, I don't see a reason why we couldn't ask that. I have a London City site where the diminution agreed is 20 million plus on a 200 million plus sale. Again, a 10% diminution. That, to me, I can't see a valuer not feeling, a genuine valuer not coming to the conclusion that having code apparatus on a site doesn't create a diminution in value. I would expect to see quite a substantial one, and actually the worst thing is in a lot of cases it's simply very off-putting, certainly for the smaller developments, for these developers to move forward with your site. So what you find is no one wants to buy it, or at least not at anything that's reasonable. Cornerstone case, is it 5k per annum or one-off payment? It's 5k per annum. Something about BT Wayleave agreement. They have different ones. The most complicated one is the A5000. Wanted to know the name of the BT Wayleave agreement. However, obviously don't sign that. Do make sure that you properly review it and add in all the things that you would need to in order to protect yourself. How is market rent determined when there is no actual market? Very difficult question, which the tribunal has been struggling with quite a lot. as I say, it's coming to a situation where consideration and compensation are merging. I would say that they're starting to look at the burden. So they're looking at the impact of the burden on the site provider and starting to assess the value there. That came out of the case in Quadrant and also in Fotheringham, the Scottish case, although that case was very unsatisfactory and ended up with quite a low rent, which is being used to the detriment of site providers. Does the West Midlands 5G model for access to street furniture for 5G densification address the issues that you've raised today? I'm afraid I'm not sure. David, please feel free to talk to me in more depth about that. I probably need to, it's probably one for a discussion. Tim, Sonex, as well as the BT Wayleave agreements that Dan mentioned, are there any more user-friendly Wayleave agreements from other providers that we should ask for? There's a lot of other providers that provide Wayleave agreements. Some of them, by the way, are not code operators. I act for a non-code operator who puts fiber into buildings. You get the advantage there, excuse me, you get the advantage there that they are not an operator, therefore the code won't apply, you don't have all of the problems that the code creates for you. They will offer a revenue share. So depending on the number of people that they sign up, you'll get a proportion of that revenue. So there are different options out there which are worth exploring. Does the code apply in fiber cable to be installed to a building from a pub in the pavement by BT? They want to install via the frontage of 2 other buildings, also in our ownership, but not the property to be served. Are we obliged to accept this? No payment is being offered. So it depends. They have powers under the code to do street works. To the extent that they are street works, they can just do those at no cost. Where they're crossing private land, however, and I would say particularly where they're crossing private land to gain access to a third party, then I think they should pay. I am, for one council, seeking valuations for all types of Wayleaves, including Wayleaves, where you are getting the fiber cable up onto the roof to a mast, and what the operator will argue is that fiber cable has already been paid for effectively by the operator that's on the building because he's got rights to be connected. My response to that is he's got rights to be connected, but generally he hasn't got a right to be connected on a Wayleave on any basis, and that there should be no reason why you shouldn't seek payment. Often the fiber operator seeks wants a perpetual Wayleave, despite the fact that the lease to the operator might be 4 years or may have 1 year left to run. They'll want a perpetual Wayleave and yet won't want to pay for it. So I think this is a really fertile area where I have to say I think there might be some payments due from the likes of BT and Virgin who want to gain access in different situations. With regards to ECC Wayleaves rather than leases, our understanding is these don't have a fixed end date. Therefore, what date should the 18-month notice to terminate state, or how should the expiry date be calculated? I wouldn't agree a perpetual ECC Wayleave. Firstly, if you do, then it's likely to have a notice process. I hope. I have seen, funnily enough, a Wayleave which had no ability to ever end, had all those wide rights over the entirety of a very large property, including access, including they could put the cable wherever they liked, hugely detrimental to the site, effectively sterilizing it. The ECC Wayleave should be a complicated 20-page document which covers lots of different things, should have a term end date, should have a break, and if it does have a break, so if you are able to terminate it on notice, then you need to align the two. You'll need to serve your contractual notice and your statutory notice. David, I've seen former Orange leases with a minimum term that requires either party to serve a minimum 12 months notice to terminate after min term expires. If they serve a Section 26 notice, does that mean they cannot terminate as a Section 26 notice period can be no more than 12 months? Well, they could do 2 notices, so they could seek to bring their contractual term to an end and serve a Section 26 notice. But yeah, I take your point. It is complicated, and I have noticed that they are trying to squeeze Section 26 notices to cover everything, and and just meet the 12-month deadline. Although how they do that with service, I don't know. Catherine Whitaker, for 54 at renewal postcode, how does modernisation of terms impact on length of term? Existing lease was initial 10 years, but T has remained in occupation under initial lease for 20 years plus. Can the T argue that the 10-year term is reasonable? Probably. The case that I was referring to earlier, which was a 54 at renewal, there the tribunal granted 10 years with 5-year break. If it's anything like the 54 at, then quite a lot of consideration is given to the tenant. David, I thought a code agreement needs to have a specified period. There is some risk here, David. It's a good point to make. The code does say that there needs to be a specified period. The argument the operators are running is that by having a period terminable on notice, that's your specified period. So, and that does have some basis in law. However, I have spoken with counsel on this point. We think there is some risk for all those Wayleave suppliers who are putting in perpetual Wayleaves, that they might not be code agreements because they don't meet that provision. But that's a very good question. Thank you, David. I think that is all the questions I've been asked. I hope that was an interesting whiz through the code. Lots and lots of stuff going on in this area, which I think is very, very interesting, although I suspect most of you probably have had enough of it already. Thank you.